So friends, basically Indian Penal Code, are doctors really aware? You can see this cartoon here. You know, what does it say? The justice, it's a tortoise. So you can judge what exactly the tortoise. It's slow. Okay. And definitely the other person, please, he's not Amit Shah. Okay. He looks like that, but he's not Amit Shah. But it's a person, you know, from the government. He's reading the IPC today. So what is the need basically? Is there really, does the doctor really need to know all these IPCs? So basically, we are going to deal today the criminal law and health professional related IPCs only. So what is the IPC? It's an official criminal code of India. It defines the offences and the quantum of punishment under different sections to it. Believe me, it extends for whole of India except Jammu and Kashmir, because they enjoy a special status and they have their own Ranbir penal code. So only Jammu and Kashmir is having a different penal code, but rest of all of India, okay, it is an IPC. It is IPC. But who are immune regarding this IPC? The President of India, the governors of all the states, diplomats, foreign diplomats, they are all immune from these IPCs. If I mean immune, means they cannot be charged under any sections of IPC. They cannot be charged. So is there a need for us to know about it? Yes, of course there is a need. Because why? The quantum of offences and the punishment thereafter is decided by IPCs. It's a criminal law and the health professionals. So there is a rise in the consumer awareness among the patients. So we should know about the IPCs. Definitely we have seen the latest one which has happened in Rajasthan. There was a wrong implication of the section of IPC and we know what has happened. Everybody knows what has happened to it. So before, if anything goes wrong, if a police charges or writes a offense against us, we have the right to know what is the IPC, under which section does the police have charged us, and definitely we can discuss with our lawyer and we can go ahead with it. So wrong implication of the section of IPC due to unknown resources. You know what is the meaning of unknown resources? There are a lot of pressure in the society, political pressure, relative pressure, so many things. So before we go ahead with the IPCs, there are 4 things which we should know, which is very important. That is fundamental elements of crime. 1, human being. To charge somebody under an IPC, he should be a human being. He should be a human being. Second is the mens rea. Now what is meaning of mens rea? Mens rea means there should be an evil mind, there should be an evil intention. For an example, a gynecologist doing an hysterectomy and the patient dies, okay, on table. But the doctor doesn't have a criminal and an evil intention of that. He is doing a surgery, okay, but death has occurred, that is definite. That needs to be proved, negligence, but he doesn't have a evil intention. So the mens rea part of it is very important in case of our doctors. Then actus reus, illegal act or omissions. So negligence and all these factors, they come into it. And the 4th most important thing is an injury to another human being. That has to be proved. Means the person has been harmed, has been injured, whether any major injury or minor injury to it, damage to the properties, everything they come under this category. So these 4 fundamental elements of crime has to be there and we should know exactly it. So what are the relevant sections of the IPC? As I told you, the criminal law and health professionals, we are going to deal only with that. So according to the provisions of the IPC 1860, any act of commission or omission is not a crime unless it is accompanied by a guilt mind. You understand? Or a or an evil mind or an evil intention. That is mens rea, what I just told you. The acts are not punishable only because it led to some mischievous results unless associated with intention or mental attitude of the person. So to commit or to prove a crime, the court has to prove that there has to be an evil intention. There has to be an evil intention. Most of the times, doctor's treatment is in good faith. So there is a section also in good faith also. There is a good faith section to it. So most of the doctors, they come. See, we are saving life of a patient in good faith. Okay, but sometimes we are unsuccessful. So that doesn't mean that we are negligent. That doesn't mean that we have created a crime. Okay, so most of the time, doctor's treatment is in good faith with the consent of the patient, and hence most of the provisions of IPCs are not applicable to the doctors unless or until there is a rashness or a gross negligence. Okay, somebody has done a laparotomy and he has forgotten a mosquito forceps inside. That's a negligence. That's a negligence. Okay, so that is not part of it. That is not part of it. So let's come and deal with the different types of sections. We are going only which is related to it. It's short because there are so many sections to it. So section 29 here, the first and the foremost thing is deals with the document. What is a document? It's very important factor when some mishap happens. It's very important because the word document denotes any matter expressed or described upon any substance by means of letters, figures or marks, or by more than one of those means intended to be used or which may be used as evidence of that matter. So one thing we should remember that documentation is very important. I think Dr. Nauranke sir is going to speak on that and we will be elaborating it. The section 52 describes the good faith. As I told you, nothing is said to be done or believed in good faith which is done or believed without due care and attention. Section 19 is related to the consent. Consent known to be given under fear or misconception. Now these are again different sections which are also important to us. One is section 176, failure to inform police whenever essential. So many times accident cases comes to our hospital, we don't inform. Now if we don't inform the police, the patient dies. The patient dies if the patient relative sues us or files a criminal case. Section 176 also can be implemented on the doctor that you have failed to inform the police during this. Section 269 to 271, they are related to spread of infectious disease and disobedience of a quarantine rule. Now this has come in limelight during the COVID rules and all these things. Okay, this is just for the information basically. Like 270 is a malignant act likely to spread infection of disease dangerous to life, disobedience to quarantine rule, and 272, 273 is related to the adulteration of food and drinks. Section 276 is the sale of drug as a different drug of preparation. We doctors don't have a right for sale of drug. We don't have a right. We cannot combine two drugs, mix it and give it to the patient. We cannot do that because we need to have a license for that. We need to have a proper registration for that to it. And if some mishap happens under section 276, you are liable for it. Section 304A, very important. This is something which has come in limelight after the Rajasthan incidents to it. It deals with the death caused by a negligent act. Whenever there is a mishap, like I told you right from the start, like hysterectomy, patient died on table, okay. There is no evil intention. There is no evil intention to it. It's a good faith. So 304A is the right section to be applied during this time. Section 306 to 309 or they are related with abetment of suicide. 307 is attempt to murder. The lady in Rajasthan was charged with 307, that is the attempt to murder. 308 is attempt to commit culpable homicide. We are going to discuss in little bit in elaborate in the next slides. 309 is attempt to commit suicide. Section 312 to 314. Again, this is important for the gynecologist people. They are related to causing miscarriage, abortion, and hiding such facts. I think there was certain incidents in Samli, I think, where the doctors were they were acquitted for that, and Section 312 were causing miscarriages. 312, 313 is causing miscarriage without woman's consent, and 314 is death caused by act done with intent to cause miscarriage. 315 to 316, they deal with the act to prevent child being born alive or to cause it to die after birth. So section 315 and 316 in detail they have given with an act done with the intent to prevent child being born alive or to cause it to die after birth, and 316 is causing death of quick unborn child by act amounting to culpable homicide. These sections are also important here in a reverse way. Like there is a mob attack, the doctor is attacked. So we should know exactly on what sections, okay, what IPC should be charged and let the police put, for the patient relatives who has attacked the doctor's way. So section 319 to 322 is related to causing hurt, grievous hurt, loss of vision, loss of hearing, or disfigurement to it. 319 is just related to hurt. Somebody is hurt. Okay. But 320 is grievous injuries or grievous hurt. 321 is voluntary causing hurt, and 322 is voluntary causing grievous injuries or hurt. 336 to 338 is deals with causing hurt by rash or negligent act. It's an act injuring life or personal safety of others. Now 336, basically a doctor who's performing a surgery but has been proved that he has intoxicated, he has taken alcohol. Okay, so he is endangering life of that patient. 337 is causing hurt by act endangering life or personal safety of others, and 338 is causing grievous injuries or hurt by act endangering life or personal safety of others. 340 to 342 are all wrongful confinement, breach of contract, and these are related to defamation part of it. Now let's go into detail about section 304 and 304A. See, there has been a lot of discrepancy while applying these sections in cases of professional negligence by doctors. Most of the time, the police authorities register the cases of professional negligence there under section 304 of IPC. But we should not let them do this. We should not let them do this. According to this section, the offense is non-bailable. First thing, 304 is non-bailable. In fact, the police should register the cases of death due to medical negligence under section 304A of IPC. A, 304 of IPC, in which the offense is bailable and the doctor can be released on bail. The basic difference in that is a section 304, there is an intentional act of negligence, while in 304A, the act is never done with the intention to cause death. Okay, so that is the intention, the evil mind to it. Okay, so this is very important. This is very important. This is the safety of our doctors. the Indian Penal Code, where 1 to 6 you can see misbehavior, the duty, use of abusive language, 3 to the duty doctors, attack on this board. Every hospital should have this board. And actually, I would suggest Dr. Mohit sir, our president, our association should print this and to give each and every members that they should have this and put it in each and every hospital. So you can see for misbehaving, almost 2 years imprisonment under section 504 is there. Use of abusive language. If you record any patient or patient relative giving abusive languages, using abusive languages against doctors, you can record it, and 504, 2 years imprisonment is there. Even a 3 to the duty doctor, 506, 3 to 7 years. Attack on duty doctor, again 3 to 10 years. Damage to the property and equipment, 4 to 7 sections is there. And forceful entry into the hospital. Nobody can enter the hospital at his will. If a doctor refuses, the doctor has all the right to refuse the treatment, okay, of a patient, only not in emergency cases. Okay, if it's a cold case, if it's a routine OPD case, he has the right to refuse. He can very well say, "Maji tabiat aaj bari nahi hai. Mala bara watat nahi." So that is a valid point. Okay. All imprisonment is for 2 years and they are non-bailable. They are non-bailable. And this is all over India. This is all over India under the Indian Penal Code. There are few common terminologies you should know, basically. Sometimes there is a summon, there is a warrant, there is a cognizable offences. आपण ऐकले ते शब्द, पण आपल्याला खरं त्याचे अर्थ आपल्याला कळत नाही की नक्की काय आहे. त्यातले खरं त्यातला तो अर्थ काय आहे, म्हणजे काय आहे ते. The summons is the process of court asking the opposite party to appear and answer the allegations preferred by the party who has brought action. It's a summon from the court. You have to attend. You have to go there, and you have to do that, because if you don't attend the summon, then the warrant comes. Warrant means an order issued by the court, magistrate, or a competent judicial authority directing a police officer to make arrest, seize, or search, or to do any other work incidental to the administration of justice. What is the cognizable offences? These are those in which a police officer may arrest without warrant. Okay, the police officer comes and says, "You have committed a cognizable offence. I have come to arrest you." Okay, the crime should come under the cognizable offence. Then only he can come without a warrant. Non-cognizable offences are those in which a police officer can't arrest without a warrant. Illegal offences are those in which bail can be granted by any law or liability. It's very important basically here that whichever section has been put on us, okay, 304A, that has to be a bailable one. Non-bailable one, you are in a suit. So non-bailable offences are offences other than the bailable offences, or an offence in which a bail can't be granted. So when do we inform police? A doctor has to inform the police in the following circumstances. 1. Cases of suspected homicide, cases of suicidal deaths, unknown unconscious patient, death on operation table, suspected unnatural death, sudden, unexpected, violent and unexplained death, instant death after treatment or reaction of medicines, married lady dying within 7 years of marriage due to any reason. So information to police shall preferably be in writing, and the written acknowledgement should be obtained. If the information is on telephone, it's a telephonic, then one must note down the name of the police officer, the buckle number, designation, and the address of the location of the police station. So can a doctor be arrested? Of course he can be. Doctors have no immunity against arrest. He can be arrested, but he can get a bail also. So always, whenever you have a police, you have to have a lawyer besides you, and you can have a bail. If a FIR is lodged by a patient or a relative, then the police may arrest the doctors. Hence, if you think that there is going to be a chaos, the relatives are going to repatriate, the relatives are going to be against you, then it's a better approach in cases where we feel that the patients or relatives may create nuisance. Will be the doctor should lodge an FIR. That's the first information report that a particular incident has happened in my hospital. These are few do's and don'ts. Inform police whenever necessary. Extend all possible cooperation to the police. Furnish copies of medical records to the police, court or relatives whenever demanded. Consent of the patient may be taken while providing information to the police. Follow the legal procedures. Have a valid informed consent for the treatment. Preserve the documents, records, especially in medico-legal or complicated cases. Insist for a PM examination if the cause of death can't be ascertained. Involve medical associations or our association, medico-legal cells, voluntary organizations. Consult your lawyer before giving any reply or statement. Don't become panicky. Don't manipulate or tamper with the documents. Don't do unlawful or unethical acts. Don't issue any false or bogus certificates. Don't neglect the treatment while completing legal formalities, especially in serious or emergency situations. So here are a few things which you should remember, which can land up you in problems. You can see it's very elaborative. I'm sorry the slide is not very clear, but it's a failure to X-ray the fractures, missing the fractures, removal of wrong organ, wrong digit, transfusion mistakes, anesthetic mishaps, tight plasters, wrong side, wrong patient, paralysis from the spine, retained objects in the abdomen or in the body cavity, surgical errors like ligation, cutting the ureters. So all these things, these are medical negligence. Okay, this needs to be tackled. This needs to be handled very carefully, and we can come out of it. Thank you so much. Thank you for your patience. This is me and my wife Maya at Antarctica. That's the South Pole. Thank you. Any questions, please? The forum is open for questions. It's very theoretical, basically. You all should know these things. We can think of printing these IPCs, and every hospital should have a file of all these IPCs and keep it as a record to it. It's very hard to remember all these things, but you can refer. You can definitely refer to it. Yes, sir.
So, Sudhir, I would like to add something.
Yes, sir, please.
IPCs are there.
Sir.
Everybody should know it.
Yeah.
Yes,
sir.
IPCs should be known by the doctors. There are certain things which are happening right now. Few of the cases which I came across last 4 or 5 years before COVID and all this. A patient was got to the police station, the police have not taken the complaint. The patient has gone to the court, and court has issued an order to police station under 204. 204 and 204A makes a difference.
Yes, sir.
204A is only equal, but 204 means you arrest the doctor and then you call, where there is no question arises. So this thing has happened with successfully 2 cases in this area, 2 hospitals. Fortunately, with good officers with DCP, because even police inspector, they don't have a power to arrest. They don't take a permission from DCP. Since I came to know, we have approached the DCP and the arrest was prevented. But this is the thing which is happening right now. And court has successfully given 2 or 3 orders in this infringement study. So mind well that this is the thing which is happening in this. Second thing, this Rangi code has gone from.
Yes, sir. Yes.
The third important thing is that right from the beginning, when we have formed the PCDA, I'm insisting that you should have a lawyer whenever the.
Absolutely. Absolutely.
To give a statement in the police station. The famous Sudhir case, I had to bring out my all four doctors just because I was having a lawyer. He was just fortunately with me from High Court. He went inside and he found out that the inner courts, they are available, so we have given them, all four doctors came out within a month. So that is the thing which I am insisting for everyone. Unfortunately, over above, two other doctors who went to the two doctors who were called to the police station and got arrested because they were not having a police
Lawyer.
So this is the thing we should avoid.
This is a take-home message, basically, what Dr. Kamal sir has told. Okay, these are pearls of wisdom. Sir, good morning.
Good morning. Good morning.
Good morning. These are pearls of wisdom. It's basically never go alone to the police station. Never. Always take your lawyer. See, just think, all this corporate world, these companies, every company has got their department, the lawyer department. Why they have it? They have to have it. Why doctors don't have it? Now I think it should be a part of it. Every hospital should tie up with one lawyer. In foreign countries, it is a compulsion. They have to do it. They have to. When there are few complicated cases where the doctor feels that the patient may die in the operation theatre, when they take the consent, the lawyer is also present in the room at that time. So that has to be there. So I think the lawyer has to be there. Now it's a time where we should need a lawyer with us. Okay. We can, I'm very frank, we can start charging a little more as a legal charges in the bill for the patient. Okay, but we should have a lawyer. We should have a lawyer. Yeah.
What about
Yes, sir. Yeah, good morning, sir.
While performing surgery, we usually take consent for vascular injuries.
Sorry, sir. Yeah.
We take consent for vascular injuries, not for nerve injuries. So, what should be written in that?
No, sir. Basically, the consent, okay, it depends upon each and individual specialty. Okay, like I'm an ENT surgeon. Okay, a simple tympanoplasty surgery. Okay, but still in my consent, it is written that you may lose your hearing. Okay, it's very clearly written because patient can land up with a infection, patient can land up with a viral infection, and he can get a sensorineural loss. The ear can be dead. I have seen few cases like that. I have seen. So you have to. It is not. If you are a vascular surgeon, you have to very specify in your consent form. Okay, you have to write each and every the vascular elements, the nerves also. What are the complications? What can happen? You have to elaborate that.
Sir, I would like to tell you one thing, sir. Procedure-specific consents are very clear.
Yeah.
It cannot be doctor-specific consent.
Yeah.
It has to be procedure-specific consent with complications to be
Yes.
mentioned and actual what book says in the consent in written hand. And that will be elaborated by Navrange sir when he in his lectures. Will be speaking more
documentation
about
and consent.
and
Sir is going
this
to.
point when on the panel discussion at NLabs. This is a very important topic which you have put forward. Thank you, sir, for making that possible. But we will actually take Navrange sir's lecture. He will elaborate us and then we'll take that in detail.
Sudhir, congratulations. Very nice presentation.
Thank you, Santosh.
Just a simple point, we come across many of the times, patients with domestic violence, the slap on the ear, the drum is perforated.
Yes.
So by now, this is the cognitive offense.
Yes.
So
It's a grievous injury.
Yes, if we say that this has to be informed to the police, patients do not agree. They do not agree, and in good faith, we give treatment, patients get better off, that's fine.
Yeah.
But if afterwards, after some time, these patients go to police or go to court, then there can be problem. So I want an opinion from the audience and the panel. If patient refuses to inform it to police, what should be our stand?
Actually, Dr. Bhalerao sir has initially every such cases has to be informed to the police.
It has to be informed to the police.
I just want to add one more question.
Santosh, I'll tell you. Just few years back, I had a summon at Shivajinagar Court. Okay, same case. A person was driving. Okay, he hit one two-wheeler person. That two-wheeler person came out. Okay, he also came out from the car, and that two-wheeler person slapped. Okay, he had a perforated drum. He had a perforated drum. There was a case. He came to me for the treatment. I did his patching. Okay, his drum was absent. After 4 years, I got a summon. After 4 years, After 4 years, I got a summon. So I just 2 minutes I take. I went to the court. Okay, so the person's lawyer he came. Okay, the patient's lawyer he came. He asked me what happened. So I said there was an injury when this patient had come. So how do you know there was injury? I said there was a perforation and there was a blood clot around, and it was a fresh perforation. So what would have happened? Well, I have to take history. So patient said that such and such person slapped me. So I have written on the things, and I have done an MLC also. So okay, fine. So he told to the judge, you see, that has happened because of the slap. Now the other person's lawyer, he came. Okay. So he said that, okay, you feel that it's a fresh perforation? Yes. Okay. Let's go little viewer's way. Okay. Before he slapped, okay, what happened in the car? He was in the car, he dashed. So there was an accident. So that ear must have hit the window of the car, and is that can cause perforation? You understood? So I said, yes, that can also cause perforation. So he said, then what is the proof? That because of my he has hit the person and he got a perforation. He must have got it before only, during their accident. So it's very difficult, lawyers play a lot of games here. Thank you. Thank you very much.
I just want to add one question.
So we take a question.
Is there any format, if there is a death in the hospital, is there any specific format of informing to the police, or we have to submit more papers at that time?
No. Incidence reports. We will see an incidence report. Unless and until there is a complaint, there has to be no papers to be submitted to the police.
That's a very good presentation.
Information. But you need to take information. Whom you have informed. The police station, the buckle number, everything, time, date, everything has to be known. And they give a number also.
Thank you, sir. It was a nice presentation.
Thank you.